Let friends in your social network know what you are reading about. The program, created by President Barack Obama in 2012, allows nearly 700,000 immigrants to live and work in the U.S. without fear of deportation. A link has been sent to your friend's email address. A link has been posted to your Facebook feed. USA Today spoke with 4 DACA recipients in Austin, Texas about the Supreme Court hearing the case that will decide the fate of the program. USATODAYWASHINGTON, a deeply divided Supreme Court blocked the Trump administration Thursday from ending a popular program that allows nearly 650,000 young, undocumented immigrants to live and work in the United States without fear of deportation. Chief Justice John Roberts, who wrote the majority opinion, called the Department of Homeland Security's action arbitrary and capricious, and therefore unlawful. The ruling was 5-4, with the court's 4 liberal justices agreeing and the 4 more conservative justices in dissent. "We do not decide whether DACA or its rescission are sound policies," Roberts said. "We address only whether the agency complied with the procedural requirement that it provide a reasoned explanation for its action. Here the agency failed to consider the conspicuous issues of whether to retain forbearance and what if anything to do about the hardship to DACA recipients." It was a similar outcome to last year's effort by the Trump administration to add a question on citizenship to the 2020 census. In that case as well, Roberts joined the 4 liberal justices in ruling that the administration had not justified its action. It also was the second major ruling this week in which the conservative court dealt a setback to the Trump administration. On Monday, it ruled 6-3 in an opinion by Associate Justice Neil Gorsuch that the LGBTQ community is protected under a federal law banning sex discrimination in the workplace. More, ruling on LGBTQ rights reveals precarious nature of Supreme Court's conservative majority. Roberts rejected the argument that the winding down of the program was a violation of the Constitution's Equal Protection Clause because of animus against Hispanics. Had the court ruled that the equal protection principle had been violated, DACA would have been more fully protected from a new attack. The court's conservatives agreed with the conclusion that there was no racial animus, only Associate Justice Sonia Sotomayor dissented from it. Associate Justice Clarence Thomas wrote the main dissent, in which he said the DACA program was unlawful from the moment President Barack Obama created it in 2012. Gorsuch and Associate Justice Samuel Alito agreed. The majority does not even attempt to explain why a court has the authority to scrutinize an agency's policy reasons for rescinding an unlawful program under the arbitrary and capricious microscope, Thomas said. The decision to countermand an unlawful agency action is clearly reasonable.